All right, today I'd like to talk to you about Smith versus United States. I think this is a fun turning point in the course in which we'll turn from examining matters of historical interpretation to thinking about how to interpret a document that has sort of existing authors. And so far in this course, I would just remind you that what I've been trying to do is to give you a little bit of a sample of all the different ways in which lawyers might characteristically reason to let you know whether you'd like to be engaged in this profession, whether it would be of interest to you, whether you would have the fortitude to make these arguments of your own. And so far, what we've done is we first looked at arguments in which there's a law and a set of facts, and the set of facts doesn't fit quite nicely with either rule that might be at play. And so you have two attorneys who try to become advocates for their own client and argue to a judge that their preferred interpretation of the facts renders it more properly under the purview of one rule than under the purview of another. And the second kind of legal reasoning that we've been studying involved abortion. It involved really an interpretation of a historical document. And so we've looked at things that count as good relative to the task of interpreting a historical document to see whether arguments for abortion might be adjudged to be good or bad based on that criteria that we discussed. And I don't know about you, but I, after a period of time, just get kind of tired talking about abortion. And so I found this case of Smith versus US to be a nice introduction of levity into the course. So you get to think about a heavier topic, and then you get to move on to thinking about something that really underneath it all is quite funny. And I hope you found it that way as well. So this lecture discusses Smith versus US. And in giving this lecture, I've assumed that you've done the reading and that you're going to give it your best attempt to understand prior to watching this video. Because really, the benefits that will incur to you from the course are really going to be struggling with the reading and trying to make something of it before coming to the lecture. I think there's just a way that you get better and better and better at finding the main point, and you just struggle by yourself for a little bit before watching a lecture or something to explicate the material. So I hope you've done that. All right, so this case to me seems quite confusing in its reasoning, and it took me several times to read this case before I really had a good sense of what was going on. And why do I think that is? Well, I think this is the case because the reasoning here looks more like a conversation between two people in which the contributions from one party have been isolated out and then listed first. So consider this very hokey conversation I've kind of dreamt up to get across my point here. Person one might say something like, "It's nice outside today." And person two might say, "Yeah, I went to the park." Person one might ask, "What did you do at the park?" And person two might say, "I brought a picnic." And person one might contribute, "Oh, one time I was attacked by a duck at the park." Person two might say, "Oh no." Now, if you were just to isolate the contributions to this conversation from one person, it would look like this. "Yeah, I went to the park. I brought a picnic. Oh no." And altogether, this conversation, or this participation at least, would look much more confusing than the conversation listed out in real time. And so what I'm afraid has happened in this case is that something very similar is going on. Basically, the legal reasoning is like a conversation between the majority and the dissent, but unfortunately, they've separated all the contributions from the majority into the first section and all the contributions from the dissent into the second section. And regrettably for our sake, they interact with one another considerably, which makes reading the case very difficult. So what I'm going to do in this lecture is present the material in the most streamlined and efficient way that I know how to do. And sometimes I'll just make the argument that the dissent or the majority make, and other times I'll show kind of a argument and a response. So I hope that at the end of this lecture, you'll have something of an understanding of what the legal reasoning was supposed to be. But before we do that, we have to look at my favorite part of the case, which is the facts. And so in the facts of this case, I think we have a real business genius on our hands because John Angus Smith noticed that the price of cocaine was much higher in Tennessee than it was in Florida. And so he could take advantage, I think, in his own mind, of this price discrepancy by going to Florida and by trading things that the Floridians valued more than the people in Tennessee did. So he went to Florida and he took with him a lot of different guns that he had modified, or had been modified, I guess we should say. And his basic idea was, I'll trade the guns for some cocaine in Florida, and I'll bring the drugs back to Tennessee and distribute it at a higher price. That makes sense because Florida is kind of a hub for drug trafficking and smuggling, and many people will import illegally drugs to Florida. So it's kind of expected that the price of drugs would be cheaper in Florida. Unfortunately for John Angus Smith, he did make a bit of a mistake. He trusted the wrong people. So he ultimately trusted his contact there, Debbie Hogue. And unfortunately for Hogue, she ended up not being so much of a friend as an informant for the local police force. So as soon as Smith got to Florida, he was hanging out with Hogue, and she recommended a buyer to him. Well, of course, the buyer was not really a good faith buyer. He was an undercover detective. And so while he was at his his hotel room, the detective came and was inquiring about cocaine. And when he learned that John Smith really wanted to obtain some cocaine, he said, well, I'm just a pawn shop owner. I don't really have any with me, but I can go back and get some. And what did John Smith offer in this trade? Well, he offered a MAC-10 submachine gun, which had been modified to fire fully automatically. And I believe there was also a silencer on this gun as well. So as far as submachine guns go, perhaps one of the coolest, I guess, from the perspective of a criminal, very desirable on the streets. But the undercover detective did not have the means to carry out the trade on the spot there. And so he went to go get cocaine. At least that's what he told John Smith. In reality, he went to get an arrest warrant. And while he was out getting the arrest warrant, though, John Angus Smith got a little bit skeeved. And so he got into his car and he drove away from the scene. And the police wanted to apprehend him while he was doing this. And so he initiated a high-speed chase in a van, which is probably not the best of his ideas. Ultimately, he was caught. He was apprehended. And when he was caught, they found a lot of different stuff in his car. They found a bunch of different guns. I think a 45 caliber pistol. They found a 9mm pistol in his waistband, a 22 caliber pistol. And in addition to the MAC-10, they found the MAC-11. And I think the difference between these two guns is just that one fires 380, one fires 9mm. But I could be wrong about that. Maybe the other one fires 45. I'm not an expert in such things, but that's something of the difference is the caliber. In any case, I believe both of the Macs had been modified to fire automatically, and at least one of them had a silencer. I believe the one he offered to trade in this grand business scheme. Well, you might think, oh, that's pretty bad. There has to be a crime located in there somewhere. Why exactly are we in the court today? What's the dispute that's brought us here? Well, the dispute is this section of the U.S. Code, U.S. 1924 C1, I believe, was the provision of the code. And that provision of the code makes it a crime for anyone to use or carry a gun during or in relation to a drug trafficking offense. And there are mandatory sentencing penalties imposed for various ways in which you could use a gun. But more relevantly for our purpose, you got an extra 5 years if you used a gun, but you got an extra 30 years if the gun was automatic or had a silencer. And so John Angus Smith is staring down an extra 30 years in addition to the high-speed chase, in addition to the drug trafficking offenses where he attempts to traffic drugs. So what we're discussing today is merely an addition to all the other junk that he's guilty of. We're just arguing about whether he deserves extra time for using a gun in relation to this offense. And so, if you'd ever like to ruin your life, I suspect that you could look no better than Smith versus US, because it's really a textbook about how to ruin your life quickly. All you need to do is just take some guns with you to Florida and then offer to trade them to an undercover detective, and you get bonus points in this task of ruining your life if they're automatic or have a silencer with them. So consider that if you want to ruin your life like John Angus Smith. Okay, so in response to this legal controversy, basically two factions form, the majority and the dissent. And what will the majority argue? The majority is ultimately going to argue that when the US Code says use a firearm during or in relation to a drug trafficking offense, the term use can mean to use as something as a token in a trade. So you can think of a trade involving two people who have tokens of barter, and they exchange those tokens. Sometimes it's money, sometimes they're just goods, but in any case, there are tokens. And so the way I'll be talking in this course is that John Smith used a firearm as a token of barter in an exchange for which he attempted to procure drugs from an undercover detective, right? The majority's opinion then is that when the code says using a firearm during or in relation to a drug trafficking crime, the phrase use can mean use as a token of barter. It can mean that. Meanwhile, the dissent has a more limited position on the matter. The dissent will argue that when the code says use a firearm, it means something much more circumscribed, which is use as a weapon and all the means characteristic of using something as a weapon. But it doesn't mean, and is not reasonable to think that it means that a firearm could be used as a token of barter and render itself under the purview of the US Code. And so with that kind of setup to the question at hand, we'll look at the particular arguments that are made and try to disambiguate and trace them as they continue this conversation. Now, I think that if you were to look at the case, you might agree with me that underneath all of the text, the majority argument for the idea that use can mean use as a token of barter. There are only two arguments for this conclusion, and the rest are really reactionary, the responses to the dissent. So there is very little original thought being put forward, I think, by the majority. A lot of what they're doing in this first part of the case is attempting to vindicate their intuition in light of what I consider to be rather strong arguments from the dissent. Now, this case was decided 6-3, I believe. So 6 of the justices agreed with the majority opinion that use could have this broad meaning to include use as a token of barter. But the dissent is comprised of only 3 voices. So fewer people accept the dissent, which kind of give you a sense about how powerful the dissent must be to really get under the majority's skin in this way. But anyway, the majority's first argument for the idea that it's fair to convict John Smith for 30 years because he used a gun when he offered to trade a MAC-10 to the detective is that if you look in a dictionary, if you look in a standard lexicon, you'll find this very broad definition of the term use, in which it can mean conversion to one's service. So anything that could be properly said to be converted to one's service exemplifies use in some way. This is the majority's argument. You look in a dictionary, you look in a legal dictionary, you find these very broad definitions about converting something to one's service. I use credit cards. You can use other people. You can use toys. You can use tables and chairs. Anything that you can convert to one's service counts as a use. And so it just seems that prima facie, trading something is converting it to your service because you have this goal of obtaining drugs in John Smith's case. And the way you sort of subserve that goal is by trading a firearm. And so in that sense, it falls squarely within the dictionary definition of the term use. And so it seems that prima facie, use can mean conversions to one's service. And so it's fair to convict John Smith for using a firearm under the purview of the US statute. That's their first argument. Now, their second argument is that if you were to look in the next section of the US Code, you'd find a provision for what happens when you illicitly use firearms in interstate commerce. And in some cases, those who illicitly use firearms in interstate commerce are required to forfeit their firearms. And the provisions for these conditions are spelled out in this statute. But one of the ways in which one might be subject to civil forfeiture of firearms is by using it in interstate commerce. And when you use something in interstate commerce, typically involves a kind of exchange. You're selling the firearm for money, and you've done so in a way that kind of, you've crossed state lines to do so. So because you can use a firearm in interstate commerce, according to a later section of the US Code, it looks like use can mean that firearms can be used as weapons. Okay, so these, I think, are the majority's only two arguments, that if you look at the dictionary, it will tell you that use can mean conversion to one service. And secondly, that if you look elsewhere in the code, the US Code will tell you that you can use a firearm in interstate commerce, which looks a lot like using something as a token and a barter. So with that kind of setup, I think it's best now to kind of set aside all the rest that the majority says, and we'll just turn to what the dissent says in response to this opinion. Now, the dissent is going to tell us that whenever we see use attached to another word, the things that are reasonable to think about once we see this attachment becomes narrower. So think about the phrase using drugs. What sorts of things would be reasonable for you to think about if I said the phrase, he uses drugs? Well, here's some things that come to my mind. I think about shooting up heroin in a bathroom. I think about snorting a line of coke off of a mirror. I think about smoking a bowl of marijuana with friends. All of these meanings kind of fall under the purview of using drugs. I think about taking acid on, putting an acid strip on one's tongue. I think about all these things when I hear the phrase, he uses drugs. All of these things, I think, would be reasonable for us to think when we hear the phrase. But I want to say that in contrast, there are other things that do not seem reasonable to think about. Think about what happens when you might have a cold and a bad cough, as I do now, and then you carefully read the back of the manufacturer's instructions on a bottle of cough syrup, and you take a dose of cough syrup that is appropriate to your weight and height and age, with the intent purpose of palliating some pre-existing illness. It seems to me that this also is a way in which one might use drugs. I mean, if I say he's using drugs, and then I point over to somebody taking a well-measured dose of cough syrup, there is a sense in which that's felicitous in the English language, though I might think that somebody less familiar with the English language would be talking that way. There is a sense in which that's true, isn't it? But would it be the kind of thing that's reasonable for me to think about when I hear the phrase, he uses drugs? I don't think so. I don't think it's reasonable for me to think about responsible use of cough syrup when I hear the phrase, he uses drugs. And the dissent's point here is that sometimes phrases can take on meanings of their own when the word use is concerned. The word use kind of constrains and circumscribes the range of available things that it would be reasonable to think about in certain contexts. And when you tie the phrase use to a firearm, the meaning really becomes something more like use as a weapon, and all the means characteristic of a weapon, be it for intimidation or discharging or injuring or maiming or hurting, or scaring or emboldening even a criminal. All these things come to mind when you think about the term use a firearm. And so it's not really reasonable to think of trading a firearm as using a firearm. When you see the phrase using a firearm, it has a range of things that are reasonable to think about, and trading one is not among those reasonable meanings. Much like when we hear the phrase he uses drugs, we wouldn't think, oh, he's responsibly taking a dose of cough syrup. We instead, I think, would think about things like smoking marijuana or snorting a line of cocaine or shooting up in a bathroom or something like that. So the majority does respond to this and their opinion. And what do they say? Well, they say that it doesn't exclude other meanings, even if we think that the phrase use a firearm usually means to use something as a weapon. They do accept, I think, in some way that that when you hear the phrase use a firearm, you would naturally think of use as a weapon, but they're skeptical of the idea that use a firearm would make it somehow unreasonable to think that it's possible for someone to use a firearm in a trade and for it to still fall under the purview of the statute. But I don't know. There is some kind of rational constraint on the idea I just told you about, at least. When you use the phrase, he uses drugs, it does seem to make it unreasonable in some way to think about some uses of drugs. Perhaps you put a bottle of cough syrup on your desk as a paperweight. Are you really using drugs in that instance? It seems like it would be manifestly unreasonable to think so, just based on the way we normally talk in our language. And so, even though perhaps it would be a bit strong to say that it's false to talk that way, to talk about using something not in relation to its intended purpose, there is some sense in which it is unreasonable to think about alternate meanings of the phrase and their extensions, just as it would be unreasonable to think about someone who, uses drugs by using cough syrup as a paperweight on their desk. So I don't know. I don't know about the majority's response here. I've never been satisfied with it. I've always found it somewhat perplexing. I've always worried about its strength. I think the dissent does have an interesting argument. Of course, what the majority will remind us of is that in American history, sometimes people can use canes in various ways. So I do think the dissent shot itself in the foot just a bit by appealing to the example of a cane. When you say that someone uses a cane, it would be most natural to think about someone using a cane to walk properly when they can't otherwise do so. But it is true that we even have verbs in our language about caning, where you use a cane to strike something or someone usually. And so I don't think the dissent picked the most strong example to illustrate the idea that sometimes it's unreasonable to think of alternate cases. They could have used something like drugs, I think, and perhaps made the point a bit stronger. But the majority is correct to point out that, at least in the case of cane, you can think about other meanings that are kind of reasonable when you use the term use. Let's look now at the dissent's second argument. If you look elsewhere in the US Code, they have these sentencing guidelines. The sentencing guidelines tell you about how guilty a person is and how much their sentence needs to be adjusted for using a gun in particular ways. So recall that under the statute we've currently been analyzing, basically there are enhanced penalties if you use a gun during or in relation to a crime involving trafficking drugs. But those penalties can be enhanced if the gun is automatic or silenced. We're talking about something a little bit different now with this provision of the code. In this provision of the code, the way in which one uses a firearm can affect their sentence as well. And there are guidelines about how a judge is to increase or maintain a sentence in these instances. So there is a 7-point adjustment upward. And this isn't like hockey or soccer or football, where your goal is to get more points if you're the criminal. If you're a criminal, you're trying to approach this like golf, where you're trying to get fewer points. So a way to lose this game really is to get the 7-point adjustment. When you achieve the high score of a 7-point adjustment, what you've been doing are you've been discharging a firearm. Discharging a firearm is seen by the code as perhaps the worst thing you could do. And then there is a lower limit, this 5-point adjustment. And in the 5-point adjustment, one displays, brandishes, or possesses a firearm. So you can think about the kind of behaviors that Congress might wish to discourage. One way you might discourage certain behaviors is by punishing one kind of behavior more severely than another kind of behavior. It's not to say that, both of these aren't all things considered undesirable, but some things are seen by Congress as plausibly worse than others. The worst thing you can do with a firearm is discharge it. Again, don't think about it too hard, because it might not be the worst thing you could do, but it's pretty bad, and it's the thing that Congress wants to discourage the most, according to the dissent at least. Now, the 5-point adjustment, it just involves brandishing, possessing, or displaying. So if during a crime you brandish, possess, or display um, a weapon, things will go a little bit better for you than if you actually discharge one. But interestingly, for the dissent, there is this middle category in which one receives a 6-point adjustment. And this 6-point adjustment occurs when someone otherwise uses a firearm, where use is sort of left undefined. Now, in my imagination, I can start filling in things that seem worse to me than brandishing, possessing, or displaying, but fall short of a full stop discharge. I'm thinking here about things like pistol whipping somebody else, and I can think about things like assaulting someone with a weapon. Now, a lot of people don't realize this, but what assault is, because it's usually associated with battery, right? Assault and battery. What assault is the creation of an apprehension of battery, where battery is an unwanted touching or physical contact. So assault is merely the creation of the apprehension that you're going to be touched in an unwanted way. So if I, make a fist at you and really get up in your face and I pretend to sort of land an uppercut near your chin, but I fall short of that and it makes you jump back, that's an assault, even though I've never touched you. And if I actually touch you in an unwanted way by actually punching your face, that would be a battery. And so that's why assault and battery often goes hand in hand, because people feel this apprehension of an imminent and unwanted touch, and then the person actually does touch them in an unwanted way. So that's why assault and battery often go hand in hand. But you could assault someone without battering them, and you can batter someone without assaulting them, such as when you sucker punch someone from behind. So they don't always go together. But it seems to me that assaulting someone with a firearm would just be pointing one at them. And it seems to me that pointing a firearm at someone is this thing that would very naturally fall short of discharge. But it's not, it's worse than just brandishing or possessing or displaying a firearm. And likewise, battering someone with a firearm in a way that doesn't involve discharging it could also be in the 6-point adjustment category as well. And so that's kind of just the way the mind works, I think, is to fill in that missing category of otherwise used. And I guess to me, this argument is somewhat compelling because it does seem like there are these other uses that would fall short of discharge, but are in some way worse than brandishing, possessing, or displaying one. Recall what the statute actually prohibits here in 924C1. It says you shouldn't use or carry a gun. And so you might have thought that merely carrying a gun or displaying someone or possessing it. I guess possessing the firearm would just be carrying it, wouldn't it? So carrying a firearm, as the code says in 924C1, seems to line up with this the sentencing guideline here, which involves possession. But that's the dissent's argument. Look, there are these other things that are otherwise used. There's this category of other uses, and those things are the things that are worse than displaying a firearm, but not as bad as firing one. And those are things that involve use as a weapon, like assaulting someone with a firearm, and then battering someone with a firearm in a way that doesn't amount to discharge. So, in the dissent's mind, those are kind of other uses, and those don't really, those are all ways you can use a gun as a weapon, and so that's a way you can tell a story about how use and the phrase use or carry a firearm can mean use as a weapon and not as a token of barter in an exchange. Now, I don't really see the majority's defense to this kind of an idea. It's always struck me as kind of odd. They still don't say that this is an exclusive argument, right? They say, oh yeah, it could mean that, and of course and this category, there could be this other section involving otherwise used as a weapon, that's fine. But ultimately, at the end of the day, use can still mean use as a token of barter in an exchange or something like that. All right, and so then the dissent comes back with a third argument against the majority. And what the dissent will say here is that if we go with the majority's interpretation, then it eventuates a very strange dichotomy. So remember how earlier in the lecture I told you about how one rhetorical strategy that you might appeal to in legal argument is to try to appeal to a reductio ad absurdum, where you take your opposition's position and you try to show how an absurd consequence could be derived. And once you show that the absurd consequence could be derived, that's in some way grounds for rejecting that argument. So what the majority is attempting to do is take the majority's argument and show how it results in a kind of absurd consequence. It'll make a really weird dichotomy. What exactly is the dichotomy? I've thought about this for a long time now, and I think I'm in a position to explain it to you. In the statute, there is the phrase, use or carry a firearm. There is the phrase, use or carry a firearm, which kind of is some evidence that Congress, in drafting the statute, intended for there to be a noteworthy difference between using a firearm and carrying one. Now, if the majority is correct, and use could have this very expansive meaning, a meaning so broad as to include use as a token of barter in an exchange, then it would seem that it's very natural to think that use could include carrying a firearm, couldn't it? So someone who puts a gun in their waistband to embolden themselves during a burglary seems to be using a firearm and no less restrictive of a sense than one who uses one as a token of barter in an exchange. But that seems weird. Why would you just include the phrase carry if it was already subsumed by the things that would be reasonable to think by the phrase use? So it seems like Congress has really slipped up here and they must have done something silly. They said use or carry, but really the phrase use already includes carrying something. So it's stupid that they included the explicit proviso or carry, because that was already subsumed under the meaning of the phrase use. So Congress there is not competent with the language. And I must confess that I do not understand the majority's response to this at all, or how it's supposed to be compelling. They again say that they only have this problem if use can mean use for anything whatsoever. But all they mean is that the term use could explain and include use as a token for barter. But of course, this is unsatisfactory, because if the phrase use can mean use as a token for barter, then we have an unanswered question about why it couldn't mean use for emboldening by putting into a waistband and carrying it or something like that. So if the phrase use can involve use as a token of barter, then what can't it mean? Where do we stop? Where do we draw the line? And so the dissent's point on this issue seems to me quite unanswered, and it leaves us feeling just a bit unsatisfactory. Next, we have this issue in which the dissent responds to the majority's argument too. Recall that the majority only really had two arguments. They were trying to look at the continuity of the use of the term use in the US Code, and they were appealing to dictionary definitions which referenced the idea that use could mean conversion to one's service. And since trading something seemed like a conversion to one's service, it was supposed to be apt in the present case. Let's look, though, at this second argument in which they say that the US Code, across various sections, talks as though use can mean something else in a different context. The statute that we're looking at just provided for certain penalties and civil forfeitures if firearms were used in commerce across state lines. And what the dissent will ultimately reply to this line of argument is that use is a very, very broad term. It's one of the first words you learn when you learn a language. If you've ever learned a language, you probably know how to say the term use in a different language, because even if you were a beginner, it's one of the terms that you knew very early on. Same thing with know, same thing with got, same thing with bought, same thing with received. A lot of these terms are very general terms that you just learn very early on in the language, because it's one of the most primitive terms in a language, we would naturally expect it to have a lot of different meanings. And the dissent replies to the majority by saying that it's not an artfully defined term, which is a way of saying that whenever Congress drafts a law, there are usually these stipulative definitions that they attach to meanings throughout. And what they do is they put these definitions of various terms at the very beginning of the statute, such that whenever you see that term recur throughout the code, you know that it has this specialized stipulative meaning. And the dissent points out that use is not one of these kinds of terms, and so it's kind of unreasonable to think that it would ever have this kind of stipulative or same meaning throughout the code. It's a very broad and expansive term that can mean drastically different things depending on the context and the thing being used. And so it would be unnatural to expect that use would have kind of a monolithic meaning throughout the US code, which explains why it's appropriate to use the phrase use to refer to using a gun in interstate commerce. The last argument appeals to the rule of lenity. So basically, this is a rule that says tie goes to the felon, right? When you play a game of blackjack and you have 21 and the dealer also has 21, tie goes to the dealer, right? Now, it's the opposite in a criminal case. The tie goes to the criminal, the accused. Shouldn't say criminal, right? It should say the accused. The tie goes to the accused. So if there is an ambiguity in a statute, the rule of lenity requires that the statute be interpreted in the accused's favor if the ambiguity is reasonable. And of course, the dissent will say, well, look, regardless of where you fall in this matter, you have to be fair-minded enough to say that reasonable people could disagree about this. After all, we're your brethren on the Supreme Court. So there are 3 justices, all who hold the position that use in the US code means use as a weapon. And the rule of lenity says if something is reasonably ambiguous, then you must construe it in favor of the accused. But the majority says, no reasonable person could hold that the phrase use means use as a weapon in the statute. That's a kind of a backhanded and nasty comment to the dissent here to say that their position isn't even reasonable. It's not even reasonable to think that use could mean use only as a weapon. So the dissent's insistence that the rule of lenity be applied is rejected. The majority really doubles down. They say that no reasonable person could hold that the phrase use in the statute means use as a weapon. Well, I don't know if you're convinced by anything I've said here. At the end of the day, I really find the dissent's argument to be just a bit stronger, in my opinion, than the majority's. But I do kind of join the majority in holding that the dissent maybe didn't use the best example by appealing to the cane. There are plenty of better examples out there that I think really illustrate how using something can be restricted to its intended purpose. Well, I think this is an interesting part of the class. Unfortunately for you and for me, I really won't ask you about it any further on the writing assignment or something like that. But I think it's a great case to read and to test your reading comprehension ability. It's undoubtedly going to help you on the LSAT and other areas you might I've lost the words, but it's going to help you as kind of a general skill in your academic pursuits. So in any case, in the next lecture, what I'll do is provide a very simple overview of Nix versus Hedden. This is a very small and short case, but it's one of the most fun because it involves an ambiguity with respect to the term tomato and how a court might resolve such an ambiguity. We can also think a little bit about the ways in which they've appealed to dictionary definitions to settle disputes about ambiguous terms. So hope you've enjoyed this. And again, apologies for being just a bit late, but got stuck in transit yesterday and kind of sick right now, if you couldn't tell from the voice. So things are just not going my way, but I hope all is well with you. And if you have questions about the writing assignment, I will be in my office hours on Friday. I'm looking forward to talking about any questions you have then. So until next time, thanks.